Thank you, Madam Speaker. I rise to make a brief contribution on behalf of the Greens. Our spokesperson in the other place, Sue Higginson, MLC, will speak more in a more fulsome manner, and also we're flagging some amendments. But I can say, Madam Speaker, that the Greens at this stage do not support this legislation. The government frames the bill as a technical and clarifying reform that updates the 2007 Act for Modern Policing Tools and Digital Technology. We have concerns, however, about the breadth of the definition of an investigative body, the retention of recordings in terms of future, and the potential for misuse of overt surveillance data against, for example, peaceful protest activity. So we're seeking to confine that potential, to reduce the potential for misuse of overt surveillance data. These issues identified for us that raise concerns are, and were echoed by the opposition, around privacy. Separate to the opposition, we have concerns about protest rights and state accountability. It is consistent with a broader pattern we've seen of expanding police surveillance capabilities without proportional safeguards or destruction requirements in terms of that evidence. The government's commitment to a 5-year review provides an avenue for later scrutiny, but it does not mitigate the immediate risks of indefinite retention and use of sensitive recordings. Obviously, no one's intending for the misuse, but we are legislators, and so we need to make sure that the law reflects that. We accept that legitimate overt use, and we say overt, use of surveillance devices that people are aware is happening, and certainly in the private domain, you can't just randomly record someone, or you can, but it's illegal. We accept that legitimate overt use of surveillance devices can be necessary for statutory functions such as compliance, investigation of corruption, and enforcement of serious violent or indeed animal cruelty offences. However, the bill currently allows officers of an investigative body to possess and retain recordings indefinitely and to potentially use them for secondary prosecutions, including for minor or non-violent offences arising, for example, from peaceful protest. And the Attorney-General, we welcome him ruling that out. We have not seen, and I'm not suggesting that the Attorney-General hasn't consulted widely, but we haven't seen any external organisation weighing in on this law. But we do know that, for example, the New South Wales Council for Civil Liberties, in their submission to the review of the Surveillance Devices Act 2007, back in 2013, when they made their submission, they noted that a high incidence of surveillance resulting in no relevant information leads to the view that greater oversight is needed, which is a paucity of argument. So I'll say that again, that a high incidence of surveillance where it results in no relevant information can actually lead to more and more oversight. They also raised concern that despite many warrants, they cited that 1,000 per year in New South Wales back in 2013, I don't know the current statistics, that despite many warrants, the indication of limited yield in terms of pertinent information leading to prosecution, it suggests that they suggested that a risk of intrusion was there without justification. And that's pretty dated. It'd be interesting to see the view of the Council for Civil Liberties on this legislation. Similarly, in 2022, the Human Rights Law Centre, in their submission to a review of the anti-protest laws, which we believe were rushed through, their submission was that New South Wales anti-protest laws are, and I quote, anti-democratic, disproportionate, and violate international human rights law, in particular the freedom of expression and peaceful assembly. So you'll have to forgive us, Attorney General, if we feel that there is a real danger that this legislation expands the risk of that. The Human Rights Law Centre also was concerned that expanded state powers for monitoring, profiling or surveying processed activity, including statements about New South Wales Police intelligence gathering, undermines protest rights. Now, I say that I'm not blind to the fact that we have neo-Nazis or actual Nazis protesting outside the Parliament, which obviously triggers vilification laws and a range of other laws. We're talking about peaceful protest and the right to protest. Madam Speaker, I won't go into detail in terms of the bill. We've heard that. We understand that the Attorney-General is seeking to modernise the surveillance framework, but for us, without some amendments in the other place, we think that we can't support it at the moment. The amendments that we plan to move in the other place are to amend Section 12, which is a possession offence, to limit investigative body retention to cases where prosecution has commenced, so body-worn evidence where prosecution is commenced for domestic and family violence, other violent offences, animal cruelty, corruption or maladministration in public office only. We will be seeking to require permanent deletion of recordings once prosecutions and appeals are finalised and where a defendant is innocent. And we want to see a prohibition in the use of retained recordings for non-violent offences connected to genuine peaceful protest. Thank you.